next witness, Mr. Jenkins.
The Commonwealth calls Marc Garcia.
Good afternoon. Come stand in front of Madam Clerk, please. Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth? Okay, sir, take the witness stand, please. Watch your step. Okay, you can adjust the microphone and please answer questions the attorneys may have.
Good afternoon, sir.
Afternoon.
Would you please tell us your name?
Marc Garcia, Senior.
All right, sir. And I know that I mentioned this to you earlier, but just as a reminder, we're not saying the names of any children at all today. You're welcome to use initials or refer to them, like my son, for example, but no names. I want to, do you have a son?
Yes.
And what is his initials?
MJ.
All right. Did MJ attend Richneck Elementary School?
Yes.
Was MJ in attendance at Richneck on January 6, 2023?
Yes.
How old was he then?
7.
On January 6 of 2023, did you go to Richneck Elementary School? Well, first of all, let me ask you this question. Did you take MJ to school?
Yes.
So was that in your car? Did you personally drop him off?
Yes, I drop him off every day.
Okay. And on that day, did you go back to Richneck Elementary School sooner than you normally would?
Yes.
When you arrived there, I want you to describe what you saw occurring without telling me what anyone was saying.
Okay. Well, getting there was a task because once you get to Jefferson, going down Richneck, it was kind of like caught on off by the cops and a lot of people trying to go there. So we had to go to the adjacent road, which is Monroe. And we had to come down Monroe, and we got to Monroe, we had to stop because there's a lot of cars. So I parked my car in somebody's house, and they said we could park there, and I got out my car, and I parked my car, and I went down the road, and there's a church that's on the right-hand side, and that's where everything was caught on by the cops, and that's where all of the confusion was going on because nobody knew what was going on.
So did you go to that church area where people were gathering with the police?
In the middle of the street.
Okay. And did you immediately see MJ there?
No.
Okay. From the time you arrive, and I know I'm asking you to estimate, but can you give us an estimate? Are you able to give us an estimate of how long it was from the time you arrived at Richneck to the time you saw your son?
Response.
This is the connection, Judge, that we have been talking about in this case between the shooting and the ensuing trauma to the children, and that came from a delayed reunification, and that came from, as we will hear in a moment, that came from the continued chaos leading to these children in a panic and a state of trauma.
Your Honor, I'm going to continue to object. Even his response to this is a narrative testimony in front of the jury.
What's the nexus to why we're here, and I guess I'm missing that. If you can expand on that, if not, it's sustained.
The nexus for why we're here. Let me look at the statute and read from the statute. 18.2.371.1. Any person responsible for the care of a child under 18 whose willful act or omission in that care was so gross, wanton, and culpable to show a reckless disregard for human life is guilty of a Class 6 felony. As to how
A delayed reunification.
the shooting,
That, yes.
Judge, the shooting occurred, and everything that has happened to these children is a follow-on from the shooting that establishes it is gross, wanton, and culpable behavior of Dr. Parker. It was the willful omission that caused these children to be separated from their parents in a state of chaos.
I sustain the objection. Next question, please.
Mr. Garcia, after you were reunited with your son, describe his demeanor, how he looked to you.
Objection again to relevance, Your Honor.
He can describe that out loud. Overruled. You may answer the question, sir. Do you need him to repeat it?
Okay. My son was confused. He was very scared and very shocked that all of this took place in his school, in which he loved.
All right. And are there any ways that you've noticed as a parent that your son is was different after the shooting versus before the shooting?
Yes.
Describe what you noticed.
Objection to lead.
And objection to relevance.
Okay, and I didn't hear, okay, leading and relevance. He can describe what he observed when he sees his son. Go ahead. Overruled.
So, my son, he's in therapy. He has to go to therapy now. He's still scared of the dark areas in which they have to be pushed in their safe room. He's not comfortable in certain situations like he used to be, like being talkative and things of that nature.
Objection, Your Honor. If I can just throw questions out on you.
Yes, sir.
Even regarding the statute, the things the Commonwealth has to prove, this is, the things that he's testifying to is not a material fact that has to be proven or established to prove that Dr. Parker is guilty of this crime. He's testifying as to things that occurred afterwards, but nothing regarding Dr. Parker's conduct or lack of conduct. So it's not relevant.
Response?
Child abuse and neglect requires a showing that the abuse is so gross, wanton, and culpable that it showed a disregard for human life. The effects of the abuse are what he is testifying to. That is what is gross, wanton, and culpable. And we're there. This is as far as I'm going with this. But the fact that the child is different after than before is relevant to whether the choices Dr. Parker made were gross, or the omissions were gross, wanton, and culpable, because this is the after effect to the children.
It can end here, but again, I'll let you finish, Mr. Rogers. But as to where we are now, I'm going to overrule defense objection. You can ask that one question. The gentleman may answer that question, but then we're going to stop. Yes, Mr. Rogers.
Just for the record. Your Honor, I might agree with Mr. Jenkins if the Commonwealth had to prove some type of serious injury, but that's not what is charged. It's felony abuse and neglect, but it's not based on any injury. It's based on my conduct and not any impact on these children.
Anything additional?
Not from me, Judge.
Okay. Do you like the attorney to repeat his question.
Yes, please.
Okay. How was your child different after the shooting versus before?
Yes.
Describe how he was different after.
Would you like me to describe before?
If
You
you,
have to answer the question
Yeah.
that he asked.
Okay.
yeah,
So after, again, my son, he doesn't like sleeping in the dark because of being in that safe room for however long they were in that safe room, being confined to an area, having, I don't know how much light it was, but he's scared of the dark, having added more light and going to therapy.
okay. And were any of those things present prior to the shooting?
No.
All right, thank you. I don't have any further questions for you.
Good afternoon, Mr. Garcia. I just have a few questions. Are you familiar with any relationship that your son had with Dr. Parker?
No.
Okay. Your son was a second grade student at Richneck, correct?
Correct.
So he was not in Ms. Zwerner's classroom, correct?
No.
Okay. You mentioned something about a safe room. Isn't it true that your son was in the gym?
No.
Your son was not in the gym when you
No.
picked him up?
No.
Okay. Where was he?
I don't know.
Oh, you don't know?
No, we were told by the police.
Oh, well, I'm not asking you to tell me what somebody told you.
Okay.
So you don't know?
No.
Okay. You filed a civil lawsuit arising from the events on January 6, 2023, correct?
Correct.
Okay. And it's filed here in this courthouse, correct?
Not sure.
You're not sure?
No. I got. You have
What-
to talk to my attorney on
I'm sorry?
that. You have to talk to my attorney on that.
Okay. You have named Dr. Parker as a defendant in your case, your civil case, correct?
Correct.
And you're seeking money damages from Dr. Parker, correct?
I'm not going to talk about that on camera because it's streaming.
Judge, I am going to make a limited objection here in that any civil suits relate to the children, and I think what he's requesting is that we not be on the air for this discussion and the cameras not continue recording while he discusses his child. And I support that request and ask the court to do that.
Response?
Well, Your Honor, he just asked a series of questions about the child on a camera. I'm asking about a civil case, asking him whether he filed a civil case. It has nothing to do with the child himself.
So the objection is overruled. Cross-examination, the questioner is allowed to examine the witness's interest in a case. And for the witness, we are not using names, we are using initials, as we previously did. So that is the protection to minors in this case. All right, you may proceed, Mr. T.
Mr. Garcia, you are seeking money damages from Dr. Ebony Parker in that civil case, correct?
Yes.
And a criminal conviction of Dr. Parker would assist in your civil case against her, wouldn't it?
I believe so.
Okay. So you have a financial interest in the outcome of this criminal trial?
Financial. What do you mean?
Well, you just stated that you believe that a criminal conviction of Dr. Parker would assist you in your civil case where you're suing for money, correct?
Yes.
Okay. So you would agree you have a financial interest in the outcome of the criminal trial, correct?
Possibly, yes.
Okay. When did the school first contact you about the shooting?
January 16th.
16th?
Yes.
Okay, so 10 days after the shooting occurred. Okay. And how did you get that notification?
I was called by the city, the Newport News Public Schools, I forgot the name of the downtown director of people, but I know her name is, but she called me at 6 o'clock on the 16th.
Okay. And do you consider that failure to notify you for 10 days a failure?
Absolutely.
And do you believe that failure is on the part of Newport News Public Schools?
I believe it's on the part of the school system as well as Newport News Public Schools.
Thank you. No further questions.
Any redirects?
Yes, Your Honor. You've indicated on cross-examination that your son, MJ, was not in Ms. Zwerner's classroom. What was his homeroom?
His homeroom was Mrs. McArthur's class.
And did he have occasion to interact with other students from other classes?
They're in the same hallway.
Now, in the immediate aftermath of this, when you picked him up, did he tell you anything about contact he had had with another student?
Objection, relevance, and hearsay.
Okay, and I was going to ask you, are you asking him to give the statement or just to?
I am going to attempt to establish possibly an excited utterance.
Okay, all right, so there's an objection.
Yes.
What's your response?
What is the legal basis for the objection? I missed it.
If you can repeat, Mr. T.
Relevance and hearsay.
Okay, so it would be hearsay unless the court finds that the excited utterance exception applies. I'll need to lay a foundation for that.
So if you can lay a foundation, and to the witness, sir, when we ask you to pause, and we can make sure that the evidence is appropriate under the rules of evidence.
Yes, ma'am.
You may proceed.
In the immediate aftermath of the event, right when you see your son, does your son speak to you about the event?
Yes.
Does your son tell you about a child he interacted with that day?
Yes.
Okay. And do you know who, just a yes or no question, do you know who that child is?
No.
Okay. When your son is telling you this, can you describe for us, without saying what he said, can you describe his demeanor, how he appeared and how he was acting, and how he sounded?
He was scared, shaky, and nervous.
Okay. Did he relate to you something that had just happened earlier that day?
Correct.
Judge, I think that is sufficient foundation as to hearsay under the excited utterance.
Yes, sir. Anything from the defense?
Yes, Your Honor. He has, Mr. Commonwealth has not established any foundation regarding excited utterances. We don't know how long before, and if we're talking about the shooting that had occurred at 2 p.m. and the father didn't pick up his child until sometime later in the afternoon, presumably hours later, then I don't see how it qualifies as an excited utterance.
May I respond to that, Judge?
Yes, sir.
The excited utterance exception is extended when the declarant is a child, because courts have recognized in Virginia the nature of being a child and brain development means that the heightened experience of an emergency extends quite some time. There are cases that I will have to look up if the court would like that involve many hours long when the child is young. The younger the child and the more traumatized they are acting, the longer the extension of the excited utterance is.
I am going to sustain the objection. The legal basis would be as such. Reading Rule 2:803, excited utterance. So an excited utterance is defined as a spontaneous or impulsive statement prompted by a startling event or condition and made by a declarant with firsthand knowledge at the time under circumstances negating deliberation. Again, my pauses are to show the pauses and breakups and how to decipher that. It has not been established that the declarant, which would be the witness's son, had firsthand knowledge at the time, as he was not in the affected classrooms, and there's been no evidence other than that being a student at school since it happened, as to how he would have gained firsthand knowledge through an appropriate way. So I'm going to sustain the objection.
I'm going to request to voir dire the witness so that I can establish exactly that.
Okay, and you're asking to do so out of the presence of the jury.
Yes, Your Honor.
All right. Ladies and gentlemen, if you kindly retire to the jury room and we'll bring it out as soon as we can. Thank you.
Please rise to the jury.
Okay, parties may have a seat. Into the witness, you're still under oath. We're going to have some additional questions for you. But one more will wait for the door to close. You may proceed.
In that moment where you were just describing his demeanor, tell us what MJ told you.
That my son sits on the last seat because they don't have any doors in their classroom. So his seat, he could hear the pop. When he heard the pop, the teacher, they heard over the walkie-talkie that someone got shot. And they got everybody scrambled into the outside of their classroom, which was in the direct line of supposedly their safe zone, which is outside of their classrooms.
Okay, let me ask you this question. Did MJ say all of that to you in that moment?
Yes.
Okay. And so, if I understand your testimony correctly, is it that he heard the gunshot and he was in a classroom that had no door?
Yes.
Okay.
He heard a pop, I believe.
A pop.
Yes.
Testimony was.
And then he had to evacuate with the school, basically.
He had to evacuate his classroom in the danger zone.
Okay.
Say that you're saying in or and the
In the danger zone, because his class has no door, so the zone of where they have to go out is outside of their classroom in that same hallway.
Okay, and he used the word danger zone.
My son?
Yes.
No.
Okay, I think he's asking you what did the child say? I mean the verbatim statement.
He was in his the safe room. He went to the safe room.
Okay.
Okay, and Mr. Rogers, you were saying something, you want to say something?
I was going to address his characterization of danger zone. I think the court has done that.
All right, continue with your vote.
Judge, I'm not going to seek to admit
Okay.
the statement. We need to bring the jury back up.
Okay.
Thank you,
Bring the jurors back in.
Mr. Garcia.
And yeah, I know you all just stood. You can keep your seats this time. And I'll explain to them. I gave you a break. It was just a few minutes ago. You can bring them out, but everybody doesn't have to stand. You all are welcome to have a seat once everyone comes in.
14 jurors in the box.
Thank you very much. Okay, the jurors have a seat. And normally they stand. I told them that they just stood. They didn't have to. So it's no disrespect to you all. It was just my command. you may finish with your questions if you have any more.
Yes, Your Honor. Mr. Garcia, had you personally ever been inside Richneck Elementary School?
Yes.
Had you personally ever gone to your son's classroom? And did your son's classroom have a door?
No.
All right, thank you. I don't have anything further.
Cross-examination?
I think we're fine.
Defense has no questions.
No question.
Okay, all right. And the status for this witness?
I would ask that he be released unless there's an objection to that.
He can be released, Your Honor.
Okay, so sir, what that means is you're released from your obligation as a witness. You may stay in the courtroom, you may leave and go about your business, and thank you, sir.
Thank you so much.